But she says, I had not received any call from my son during this relevant period.
I think you're drawing too much inference on this.
Our
So what
location-
becomes of that evidence? No, you want to declare her hostile or just
I
put
do not
questions?
want to declare her hostile. I want to seek explanation from her. To the questions asked, did you state anything before the commissioner? She says yes, which is not correct. Able to show to the honorable court that the witness is lying. ಸುಳ್ಳು ಹೇಳ್ತಿದ್ದಾರೆ ಅಂತಿದ್ರೆ ಅದರ ಬಗ್ಗೆ 154 ಅಲ್ಲಿ ವಿತೌಟ್
Lying or only trying? Yes, sir.
Not 154 of the Evidence Act. I'll confine myself to the points which
Ashte,
just
that's all.
4 lines. That's all. I'll not trouble you a lot again. Examination in chief of this PW1 was conducted on 17/12/2025.
1712?
12/2025.
Yes.
Cross examination by the counsel for A1 was done on 17/12 and 18/12/2025. The counsel for A2 sought time. And it was adjourned. Cross examination of PW1 at the instance of A2 was adjourned to 29/12/2025. There was gap of about 11 or 12 days. Can I draw your lordship's kind attention to page 414? The first point, why we sought permission. But I'll confine myself to the point of law that if I am able to bring to your lordship kind notice that what witness has stated is apparently false, then 154 comes into picture.
414.
414. This is the call record detail CDR. Serial number 1 and 2 may kindly be seen.
Vinayak Nagar.
Vinayak Nagar. Idaralli your lordship will find in the second column these two telephones.
Call out.
Call out idiyalla. Adu they are standing in the name of the father of the deceased Kashinathayya, whose name appears as a sub name B, Kashinath Shivanagowda.
Aito. Who has called?
This was used by the PW1 mother Uchi, where she admits. But the call, your lordship will find, there is a call duration of 27 seconds and 47 seconds. On the date of incident, your lordship will find 8/6/2024, serial number 2.
Called to whom, sir? From whose phone to whose phone?
Mother's phone to the phone of the deceased.
So what?
This is 1 nimsha. The lordship will also find tower location. This is close to the scene of crime. What mother says is, this is a documentary evidence available. There is a call between mother and son and during the time of incident, in the afternoon. What mother says in the cross examination is at page 336. But she says, I had not received any call from my son during this relevant period.
I think you're drawing too much inference on this.
She says, I have not received any call. But the records indicate that she in fact had received call and the tower
So
location.
what becomes of that evidence? Now you want to you turn her hostile and cross-examine
Yes, ma'am.
on these things, or tacitly cross-examine without declaring her hostile? That is your
Now
submission.
she says this phone belongs.
Only these two instances you want?
This one though, there's one more
Then-
your lordship will find. Page 367, the inquest.
Hmm.
ಮೃತನು ಜೀವಂತವಾಗಿದ್ದಾಗ ದಿನಾಂಕ 8/6/24 ಮಧ್ಯಾಹ್ನ ಸುಮಾರು 2:30 ಗಂಟೆಯ ಸಮಯದಲ್ಲಿ ಮೃತನ ತಾಯಿ ಶ್ರೀಮತಿ ರತ್ನಪ್ರಭಾರವರು ತನ್ನ ಮಗನಾದ ರೇಣುಕಾಸ್ವಾಮಿಗೆ ಫೋನ್ ಕರೆ ಮಾಡಿ ಮಾತನಾಡಿದ್ದು, ಮೃತನು ತನ್ನ ಹಳೆಯ 4 ಜನ ಸ್ನೇಹಿತರೊಂದಿಗೆ ಹೊರಗಡೆ ಹೋಗುತ್ತಿದ್ದು, ಆನ್ ಸರ್ಟನ್ ಇಂಪಾರ್ಟೆಂಟ್ ಆಸ್ಪೆಕ್ಟ್ ಸಿಂಪ್ಲಿ ಸೇಸ್ ಐ ಹ್ಯಾವ್ ನಾಟ್ ಗಿವನ್ ಸಚ್ ಸ್ಟೇಟ್ಮೆಂಟ್, ಐ ಹ್ಯಾವ್ ನಾಟ್ ರಿಸೀವ್ಡ್ ಕಾಲ್, which goes contrary to the documentary evidence available on record. Then my lord, page 376 your lordship will find. ನಂತರ ಆತ fourth line,
ನಂತರ ಆತ ಮಧ್ಯಾಹ್ನದ ಸಮಯದಲ್ಲಿ
ನನ್ನ ಹೆಂಡತಿಗೆ ಫೋನ್ ಕರೆ ಮಾಡಿ,
ನನ್ನ ಹೆಂಡತಿಗೆ ಫೋನ್ ಕರೆ ಮಾಡಿದ್ರೆ ಯಾರಿಗೆ? ಹೂ ಇಸ್ ಸ್ಪೀಕಿಂಗ್?
ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ದಿ ಫಾದರ್.
That's the
ಮಧ್ಯಾಹ್ನ ಊಟಕ್ಕೆ ಮನೆಗೆ ಬರೋದಿಲ್ಲ, ನಾನು ನನ್ನ ಹಳೆಯ ಸ್ನೇಹಿತರ ಜೊತೆಯಲ್ಲಿ ಕಾರಿನ ಹೊರಗಡೆ ಊಟಕ್ಕೆ ಹೋಗೋದಾಗಿ ತಿಳಿಸಿದನು. ಮದರ್ ಸೇಸ್ ನೋ, ಮೈ ಹಸ್ಬೆಂಡ್ ಹ್ಯಾಸ್ ನೆವರ್ ಸ್ಟೇಟೆಡ್. Of course, it is a different issue. It should have been confronted to husband. No, the fact remains. The call record details indicate the location of the deceased, at the scene of offense, where location will be generated only when
ಬೇರೆ ಎವಿಡೆನ್ಸ್ ಇಲ್ವಾ?
ಬೇರೆ ಎವಿಡೆನ್ಸ್ ಡೆಫಿನೆಟ್ಲಿ ಇದೆ. ಬೇರೆ ಎವಿಡೆನ್ಸ್ ಡೆಫಿನೆಟ್ಲಿ. This is not one. Then kindly look at the second one. ಶವ ಮಹಜರ್ ಮಾಡುವ ಕಾಲಕ್ಕೆ ನಾವುಗಳು ಮತ್ತು ಸಂಬಂಧಿಕರು ಹಾಗೂ ವೈದ್ಯರು ಇದ್ದರು. ಅದೇ ರೀತಿಯಾಗಿ ಪೊಲೀಸರು ಇದ್ದರು. ಶವದ ಯಾವ ಭಾಗಗಳಿಗೆ ಯಾವ ಆಯುಧಗಳಿಂದ ಗಾಯಗಳಾಗಿವೆ ಎಂದು ಪೊಲೀಸರು ತೋರಿಸಿದರು. ಸಾಕ್ಷಿದಾರರು ಮುಂದುವರಿದು ನಾವು ನೋಡಿರುತ್ತೇವೆ ಎಂದು ನುಡಿದಿರುತ್ತಾರೆ. ನಾವು ನೋಡಿದಂತೆ ಪೊಲೀಸರು ತೋರಿಸಿದಂತೆ ಯಾವ ಯಾವ ಆಯುಧದಿಂದ ಆಗಿರುತ್ತದೆ ಅಂತ ಪೊಲೀಸರು
ಅಲ್ಲ, ಇದು ಯಾರು? ಮದರ್
ಡಾಕ್ಟರ್ ಬಳಿ ಆಯುಧಗಳು ಇರುವುದನ್ನು ನಾನು ನೋಡಿರ, ಪೊಲೀಸರ ಬಳಿ ಇರುವುದನ್ನು ನಾನು ನೋಡಿರುತ್ತೇನೆ. ದಿಸ್ ಶವ ಮಹಜರ್ is on 11/6/24, where spot measure and recovery of the weapons happens only on 12/6. This again her statement
contradictory.
not completely contrary not to the documents. Then, my lord, your lordship will find ಪೊಲೀಸರಿಗೆ ರೇಣುಕಾಸ್ವಾಮಿ ಅನ್ನೋದು ಆತನ ID ಕಾರ್ಡಿನಿಂದ ಗೊತ್ತಾಯಿತು. But in the entire case of the prosecution, ID card is not recovered at all. She says police came to know that this is my son only through ID card, which is not again apparently. Then not the last one. ಪೊಲೀಸರ ಮುಂದೆ 3 ಬಾರಿ ಹೇಳಿಕೆ ಕೊಡುವಾಗ ನನ್ನ ಮಗ ಪ್ರತಿ ಶನಿವಾರದಂದು so and so. All that she has given statement is only once, 161. Not when I sought permission under section 154 and sought permission of the Honorable Court. The main contention of the counsel for A2 was, no, she has stated 3 statements. Where are the other 2? They have suppressed. But in fact, as per the records, it is only one statement that she has given.
161 statement ondena.
Onde irodu.
These are the contradictions.
These are the major contradictions.
No, you want to declare her hostile or just
I
put
do not
questions?
want to declare her hostile. I want to seek explanation from her. Where are the? Did you really give? What she says is, I met police commissioner. Then I went to hospital for inquest. Then I went to police station for giving statement. She to the questions asked, did you state anything before the commissioner? She says yes. Then did you state anything during inquest? She says yes, which is not correct. I want to ask whether it was only oral or written.
What's the judgment?
Please, may I just
instances idena?
Instances ido. All that all the judgment says, if I am able to show to the Honorable Court that the witness is lying. ಸುಳ್ಳು ಹೇಳ್ತಿದ್ದಾರೆ ಅಂತಿದ್ರೆ ಅದರ ಬಗ್ಗೆ 154 ಅಲ್ಲಿ without
lying or only trying? Trying to lie. Yes.
And things go contrary to call record details.
We'll see,
Mother
yes.
not supporting, but is very difficult. Please.
Sir.
In this case, my lord, the witness, my lord, is the mother. My lord, she has deposed.
Prosecution witness.
Yeah, prosecution witness. She has deposed entire evidence in support of the prosecution. She has not turned hostile at the stage of examination chief. My lord, the term was next is for adverse party to cross-examine. My lord, adverse party, that is accused counsel, has put certain question. He has given admission that has been recorded. Even those admissions are not required clarification at the stage of re-examination. This is very important, Your Lordship. If at all, if any ambiguity is there, the stage is there at the re-examination stage. Re-examination was nil.
Re-examination.
I'm sorry. Just to clarify,
re-examination
I
is
sought
nil.
re-examination. I said, permit me to question either as re-examination or under 154(1). That was my prayer.
Re-examination is rejected.
That is both are rejected. Your Lordship will find my on my prayer.
ಅಲ್ಲ prayer ಇರಲಿ ಆರ್ಡರ್ ಏನಾಗಿದೆ?
ಆರ್ಡರ್ ಅಲ್ಲಿ 154 ಮಾಡಕ್ ಬರಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ.
Yes, Pasha sir.
Please, Your Lord. My lord, re-examination stage also, as per the trial court, my lord, that it does not come any question to be put under re-examination because there is no ambiguity. Lord, merely because some inconsistent evidence is deposed. There is no inconsistency, my lord, that she has not given evidence contrary to examination chief. This is very important. She has not given evidence inconsistent to examination chief. But she has admitted certain questions which were put in the cross-examination, which were required for the defense. Well, the purpose of cross-examination is to test the veracity of the witness.
Correct.
Well, the admissions were elicited. Those admissions may speak some additional fact, which is to even to the extent of.
But why was re-examination could have been permitted instead of 154?
As the hearing progressed in the Renukaswamy murder case, the Karnataka High Court examined the prosecution's plea concerning Ratnaprabha, the mother of the deceased, and a prosecution witness. The prosecution argued that a Section 161 CRPC statement was inconsistent with the technical evidence and documents collected during the investigation, and therefore sought permission to cross-examine her under Section 154 of the Evidence Act. The defense opposed the request, arguing that prosecution could not simply challenge the testimony of the deceased mother in the manner it sought to do. Senior advocate, appearing for actor Darshan, and counsel for the other accused relied on judicial precedents to support their objections. The trial court had earlier rejected the prosecution's application in January 2026. After hearing detailed arguments from both sides, Justice Nagaprasanna reserved the order. The High Court will now decide whether the prosecution should be permitted to cross-examine Ratnaprabha in the manner requested.